The House Criminal Justice Committee will come to order. Welcome to this joint hearing between the House Criminal Justice Committee and the Senate Civil Rights, Judiciary, and Public Safety Committees. Or one committee, actually. They do all that in one committee. Would the clerk please take attendance?
Chair Hope.
Here.
Representatives Andrews. Here. Carter. Present. Green. Young. Here. Arpit. Here. Diemendorf. Cerniglu. Here. Pillar.
Yes.
Mueller.
Here.
Fasad.
Here.
Harris.
Here.
Begol.
Here.
Madam Chair, you have 11 members present. You have a quorum.
Thank you. Representative Cerniglu moves to adopt the minutes from the September 12th meeting. Without objection, the minutes are adopted.
The Senate Committee on Civil Rights, Judiciary, and Public Safety is called to order. Will the clerk please call and announce the roll?
Chair Chang.
Here.
Senator Schink.
Here.
Senator Voino. Here. Senator Irwin. Here. Senator Santana. Senator Runstead. Senator Johnson. Madam Chair, you have 4 members present. There is a quorum.
All right, thanks very much. I'll entertain a motion to adopt the committee minutes from the September 14th, 2023 meeting. Motion made by Senator Schink. Without objection, the minutes are adopted.
We'll now hear testimony on House Bills 4630, 4631, 4632, and 4633. Here to testify in support are Representative Leitner, Marcella Westrate from the Michigan Indigent Defense Commission, Jonathan Sachs and Brad Hall from the State Appellate Defender's Office, and Samantha Gibson from the Michigan Association of Counties.
And we do have Senator Schink as well, and she'll be speaking from her seat.
Oh, I'm sorry, Rep. Mueller as well. Oh, there you are. I can't, I'm too short. I need a booster seat.
We're a unified team.
Go ahead, Rep, whenever you're ready.
Thank you, Madam Chair and members of the committee. Thank you for the opportunity to testify in support of my legislation, House Bills 4630 and 4631. It's been my pleasure to work with my colleagues to craft this legislation, the Justice for Kids and Communities package, particularly the language of the legislation you have before you. Together, 4630 and 4631 would ensure that every young person, regardless of their circumstances, receives fair and just legal representation. Free legal counsel is already available to indigent adults, and indigent juveniles should not be any different. Moreover, this legislation would increase youth representation and advocacy by adding additional specialized members to the Michigan Indigent Defense Commission and the State Appellate Defender's Office. The passage of these bills would require the alignment of current standards and the development of new ones to address the unique needs and circumstances of youth in the juvenile justice system. Appropriately, it would also require specialized training for professionals working with youth in this environment. By establishing appropriate guidelines and providing proper training, we can ensure young individuals receive fair treatment, access to necessary resources, and achieve opportunities for rehabilitation. Again, thank you for your time and attention on this matter, and if you have any questions, I have a team of people here to help with any technical assistance I may need.
Very good. Representative Mueller?
Thank you, Madam Chair. My bill is pretty self-explanatory. It's about 5, lines long, and basically it just says that the department, DHHS, can change the per diem rates for the county within the appropriated amount that the legislature gives for housing.
Thank you.
Senator Schink?
Thank you, chairs. I'm the sponsor of SB 424 and SB 425, making sure that children have the same access to legal representation as adults, especially if they or their families do not have the resources to afford a lawyer. As we know, they often do not, is the point of these bills. SB 424 concerns the Michigan Indigent Defense Commission, responsible for ensuring the public defense system is cost-effective and constitutional for those who cannot afford to pay a lawyer. It requires alignment of current standards and development of new standards with specific considerations for the representation of youth in the juvenile justice system, including requirements for specialized training for those who represent them. SB 424 also explicitly specifies that the Commission will serve indigent adults and indigent children. It prohibits youths from waiving their right to counsel unless they are advised on the consequences and the waivers on the record and in writing. Kids in the justice system are often scared, overwhelmed, and don't know how to make these choices on their own, and this avoids inadvertent coercion into waiving their rights. SB 425 concerns the State Appellate Defender Commission, which we often call SADO, which is responsible for providing appellate defense for indigent defendants who can't afford legal defense in appellate cases, and they're here today to speak more completely on the bills. SB 425 specifies 2 members that must be added to the commission, and they must be non-attorneys who've been affected by the youth or adult justice system. That allows them to bring their lived experiences to bear. SB 425 also explicitly specifies that the Commission will serve indigent adults and indigent children in appellate cases. Previously, the law did not provide for indigent child defense in appellate cases, and this results in inadequate and inconsistent services and case management for them. Finally, SB 425 creates a system for indigent defense responsible for paying a reasonable expense for the appellate defender services. Thank you, and I will move on to the next.
Thank you, Senator. We'll now hear from Ms. Westrate.
Good morning. Members of the Senate Committee on Civil Rights, Judiciary, and Public Safety, and the House Committee on Criminal Justice, my name is Marcella Westrate, and I'm here today on behalf of the Michigan Indigent Defense Commission. Thank you so much for the opportunity to speak about the bill to expand our act to include youth clients, and thank you to Representative Leitner and Senator Schenck for introducing this legislation. In many respects, the road to reform Michigan's youth system mirrors what the state and legislators did when our commission was created 10 years ago. The creation of the MIDC followed an assessment by a national organization and an advisory group appointed by the governor. The legislature then passed the bills that created the MIDC. In 2020, the National Juvenile Defense Center, which is now the Galt Center, issued an assessment of Michigan's youth defense system, working with courts and stakeholders throughout the state. As a result of that study, Governor Whitmer created the Task Force on Juvenile Justice Reform, which made recommendations including the expansion of the MIDC Act. Previous speakers have already given you the highlights of this legislation. The commissioners support this legislation and this expansion and are ready to work to implement the changes, and I'm happy to answer any questions you have about the MIDC.
Thank you. Now we'll hear from Jonathan Sachs and Brad Hall from SADO.
Thank you, Chair. Thank you, Chair Hope and Chair Chang and colleagues for holding this hearing, and thanks to Representative Leitner and Senator Schenck for introducing the legislation. My name is Jonathan Sachs. I'm Director of the State Appellate Defender Office. At SADO, we have a public defender division that represents 25% of people appealing pending criminal convictions, and a Michigan Appellate Assigned Counsel system that represents the other 75% through private attorneys. My colleague Brad Hall will speak on the aspect of the legislation that deals with payment of that system, and I'll speak briefly on the youth defense piece. In 2020, the Galt Center, as Ms. Westrate indicated, now the National Juvenile Defender Center, released a report, among other things, talking about appellate representation of juvenile delinquency cases. The report noted that Michigan's system of appellate defense was virtually non-existent, that there approximately were 20 appeals per year, even though there were over 7,000 trial-level cases that in theory could have been eligible for appeal. The near complete lack of appeals in delinquencies deprive some of the most vulnerable people in the justice system of appellate review and error correction, a fundamental function of what we do in appeals. Partly as a result of that study, the task force recommendation was to expand SADO to include appellate services to juveniles. We've been doing that for a while through a grant that Max has been implementing, a 3-year federal grant to expand indigent appellate representation for youth. Josh Peace, our program manager, is here, and he has set new standards standards for that, and also has helped facilitate new court rules for that representation. We've also taken on a number of youth clients. Most notably in Hillsdale County, there was a case that got some press where some parents never realized that as a result of their report of incorrigibility of their child that he might get locked up in detention center. And he received representation on appeal as a result of this work. Thank you for your support. We're looking forward to answering questions, and I'll turn it over to Mr. Hall to talk about the appellate counsel payment piece.
Thank you all, legislators, chairs, Hope and Chang, and Representative Leitner especially, for hearing from us. My name is Brad Hall. I'm the administrator of the Michigan Appellate Assigned Counsel System, or MACS, and we oversee appointed appellate representation for over 75% of indigent individuals appealing their convictions and sentences in Michigan, the non-SATO cases, the private attorneys. 10 years ago, our system was in a crisis, and there were a lot of reasons for this. But we were failing the individuals we were responsible for serving. The most important, the primary reason was really funding. There was no state funding for our system. Attorney fees paid to the private attorneys who represented 3,000 individuals a year were paid entirely by counties. And for that reason, for decades, those fees stagnated. They were inconsistent and they were often unconscionable, paying attorneys $25 an hour or less, or flat fees of $400 that disincentivized quality representation and effectively required the attorneys to handle more cases than a SATO counterpart or national standards would allow. Over the last 10 years, with our partners in the Michigan Supreme Court and our commission, and especially the counties, we have reformed that system. I am proud to say nearly all circuit courts and counties in this state now pay consistent and more reasonable attorney fees of $50 or $75 an hour, and that has come at an expense to counties voluntarily of over $1 million annually. That has been a remarkable success story in state government and court administration, but it is at risk. Because of other reforms to our indigent defense system, $50 and $75 an hour is no longer competitive in the market for good, quality, conscientious lawyers. And we cannot go back to the counties and ask them to double their voluntary contributions. This year, with the appropriation, this state has invested $3.2 million in a new state fund to reimburse counties now on a one-to-one basis for payment of attorney fees consistent with new MIDC standards. So the counties can now pay $130 to $142 an hour for appellate felony representation consistent with MIDC rates without any new expenses to the counties. They can now do it. The state is now a stakeholder in investing in the system. It is exactly the shot in the arm we needed, and it is exactly what we needed to prepare the system and solidify it to take on the new appeals for youth in delinquency appeals and adjudications. This bill would codify that state reimbursement and would make clear to counties, to circuit courts, to all stakeholders that the state of Michigan is here as a partner in providing quality appellate representation to all indigent individuals appealing their convictions and sentences or their delinquency adjudications in Michigan. Thank you all.
Thank you. And now Ms. Gibson.
Thank you, Chairwoman Hope and Chair Chang. As stated, my name is Samantha Gibson. I'm a Government Affairs Associate at the Michigan Association of Counties. Thank you for allowing me to testify today in support of House Bill 4630. I do want to note we support the SATO bill as well, but I will keep my comments to 4630. The bills are very similar in language. MAC supports the expansion of the MIDC to include youth indigent defense services. Much work has gone into this legislation, and MAC support is contingent on two items. First is the removal of the compounding clause language that is in the introduced version of this bill. With the work of Representative Leitner, Chair Hope and her staff, Laura and MIDC staff, we were able to avoid this language as well as any increase to the local share for MIDC services. And the second is ensuring the MIDC grant remains a disbursement rather than a reimbursement model. Under this legislation, local indigent defense systems would receive 40% of their total grant amount up front, with the remaining 60% dispersed in 3 increments of 20%. Again, MAC worked alongside legislators, Laura, and MIDC staff to create clarifying language on the updated grant disbursement model. With these changes included in an H2 substitute, MAC is able to support House Bill 4630 and its companion bill, Senate Bill 424. Thank you, and I'm happy to answer any questions.
Thank you. We do have a question from Representative Filler.
Sure, I actually have 2 questions with the chair's permission. Thank you. What happens right now in regards to indigent youth that you think is not happening, is not working correctly in the process? What is this fixing? I mean, if you're indigent and you go in front, you commit some sort of more serious crime, go in front of a juvenile court, you know, what is going wrong, I guess, in someone's opinion, that we're fixing here?
Thanks, Representative Filler. It's a good question, and I'll address just the appellate piece of that. What we see, what the statistics from the Gold Center report showed us, is that even though there are thousands of potential appeals, it's a system that doesn't really exist. There's no culture of appeals. There are only just or court rules that required appellate rights to be read, and because of that, there's no infrastructure when we start to see those appeals. In the adult system, approximately a quarter of folks who are convicted by jury, or even more, close to 40% by jury trials appeal, and approximately 10% of people who plead guilty or no contest appeal. We see in the youth system far less than 1% of either of those. So the first issue is the appellate system isn't there. We see the impact of that. There was one example that got a lot of publicity a couple years ago was a girl named Grace out of Oakland County who was ended up being placed in juvenile detention for not doing remote homework, and there was no idea that an appeal could even happen there. Pro bono attorneys came in, ultimately litigated an appeal for her, and things moved as they should have without her in detention. I mentioned the Hillsdale example. There was no appeal there. Nobody even knew he could appeal after the detention, which was the last impact of what his parents wanted when they reported him for non-criminal activity. And once folks knew there was appeal there, once again, we were able to get pro bono attorneys to step in. But what we lack is a proper operated system, and until recently, the court rules that will allow for appeals and a structure to represent people. And that's what we're looking to have change and the systems that will be fixed.
And what is the cost to the state?
For now, because those numbers are not substantial, we expect the cost to be not very high. This year's budget in anticipation, and because the Michigan Appellate Assigned Counsel system could start doing this through a court rule change and through commission decision, adds a few positions to the appellate defender staff to start doing this work. As appeals increase, we would expect a need for some new staff. But the way the statute works is 25% of folks are represented by the Public Defender Division, 75% by the assigned counsel system. So the majority of appeals would be paid for by the state through a one-to-one match, not through new employees, and then the smaller amount through new employees. In the overall indigent defense system spending, which is now, and it's an excellent development for the state of Michigan. It's now well over $150 million for trial level appeals through the Michigan Indigent Defense Commission. For the appellate system, we expect long term for this to be a very small fraction of that for the expansion to youth appeals.
And a quick follow-up on a different bill, with your permission. Tried to pull the first two together. Thanks, Chair. House Bill 4632, it's the increase or decrease the per diem rate. I guess as I read the bill, typically that's been a legislative function, but this looks like it gives it to DHH, the responsibility is given to DHHS to have the ability to increase or decrease. Could anyone speak to that? Because that strikes me as a major change. It's House Bill 4632.
Well, I'll just tell you a little bit. So this bill actually probably should have been tie-barred with Senator Santana's bill, and is it your bill with the child care fund? I can't remember who has the House bill. Morse. Oh yeah, that makes sense. It probably should have been tie-barred to that, because it's hard to assign a single per diem rate when we only have a couple of places that can actually take kids in our state. And so sometimes in order for that rate or that reimbursement to happen and for them not to necessarily lose money, it needs to be adjusted. So I think it's a proper function under HHS, under the Child Care Fund, to be flexible. And then going back to your other one, because Jonathan referred to SATO, I'm sorry, I'll make it super quick, but indigent defense is, this is bringing parity with the adult system, because the kids don't have the same opportunities in our justice system as the adults do right now. And so it's bringing uniform standards across the state for all kids in our justice system.
Thanks very much. We have a question from Senator Runstead.
Thank you. I also have same concerns about the department making the decision on the reimbursements as opposed to the legislature. In terms of the cost, in talking with some of the sheriffs, when MIDC was initially created, counties were provided with grants to help them get operational, retrofitting buildings, hirings, et cetera. But even with these grants, counties took on an extra cost since the courts did not collect monies from those who were partially indigent. Is there a plan to reimburse the counties for the additional costs?
So right now, the plan is obviously to bring parity, like I said, with the adult system. So a lot of their, well, let me just back up. None of the indigent defense money could build new buildings, okay? We put that in legislative language early on. Because, you know, some people were asking for tons of grant money, and you can probably touch on this with the MIDC. But they were asking for tons of grant money to not only retrofit, but add on to buildings, build new buildings, and that wasn't the intent. The intent was to just have basically, you know, a single little room or something so someone could speak without somebody else knowing what was going on. But through the Child Care Fund, which is a big part of this package, you guys heard it a couple of weeks ago or whatever, the reimbursement goes up also in Child Care Fund services that are provided by juveniles. So there's a lot of technicalities as far as Child Care funds and juveniles. Now, indigent defense will have to add to their current budget because we're expanding the commission as well to add specialized youth professionals, is what I'm going to call it, to MIDC. Plus, there's going to be standards that are going to happen, you know, as far as education as well. We're asking that the counties have a person in their offices just for education as well. But I think this is why we're having these conversations in the open, so we know what's out there and what all the concerns are. And, you know, this is the first real hearing, so.
So there wasn't money allocated in the past budget, it would have to be new money allocated, and I'm presuming, and if so, do we have an estimate of what that cost would be?
We don't really know the estimated cost right now because we haven't dealt with juvenile indigent populations right now. So our current budget for MIDC is like 220 million-ish, and the youth population is probably going to be about 60% of that. Now, if they're indigent, maybe, you know, it's going to be about 60%. That's like a best guess right now. As far as the other bills in this package, we did appropriate money to implement juvenile justice bills. So I think moving forward, we'll be in a good place. But this is one of those things that it's like you might ask the question, why is it so expensive? It's because it's worth it. You know, we're making the investment up front in these kids on the front side of their, I'm going to say, interactions with law enforcement in the justice system, and then hopefully diverting them away so they're not in our correction system shortly thereafter.
Thank you.
Representative Filler?
Yeah, maybe I just don't understand indigent defense as a concept, and aren't all kids indigent? You know, in generally, they don't have money, right? They don't make salary, they don't make income. So is there like a parent income test when you go through the youth system, or how does that work?
Well, kids aren't afforded the same opportunity as our normal indigent. I know it's weird and it's a weird concept. You're like, what the heck? So right now that burden is on the parents. So we have, you know, tons of additional fees, the actual attorney fees and such. And like Jonathan referred to in SATO as well, juveniles aren't accounted for in the current law. And so again, it's bringing parity in the systems with the same opportunities adults have, because kids don't have the same. Yes, they are considered indigent, most of them, right from the get-go, because, you know, they're juveniles. They're not gonna have a normal career job at that point.
Ms. Westrate, did you want to add anything?
MIDC has an indigency standard as well, and as part of this process, we'll look at the standards that we already have and expand those to include our youth clients, and so that'll be part of this review. And there's also a definition of indigency in the bill, too, that we'll fall back on.
Okay, go ahead, Rep. Filler.
Are we taking testimony, or did we on House Bill 4633? This is Representative Breen dealing with factors for waiving a juvenile into the adult system, I believe.
Yeah, that's part of today's presentation.
Okay, did anyone present on that bill? I'm not sure if I heard.
Not specifically.
Okay. Do you know if anyone's going to take questions on that one today?
Is anyone prepared to answer questions on that? No?
Okay.
4633.
I'm interested in discussing that bill at some point. Thanks, Chair.
We can get your questions answered, though, before we vote.
Yeah, I'm actually really interested in the waiving process. I mean, typically, if you're a 15-year-old that commits attempted murder, arson, kidnapping, CSC, the more serious crimes, then the prosecutor will, and I never served as a prosecutor at that level, so, but they'll essentially ask the court to waive that very serious offense into the adult system, and then there'll be an argument back and forth whether or not that's appropriate. And of course, the adult system is much more difficult, much more stark than the juvenile system, and so it's a pretty serious thing to waive. And so this bill suggests that we're changing some factors, and I'm, of course, very interested in that because then we're dealing with very serious crimes like murder, attempted murder, criminal sexual conduct. So I'd just like to learn a little bit more about that bill. Thank you, Chair.
I don't see any more questions, so we will proceed with cards. Thank you all for your testimony. Thanks. On House Bill 4630, Paige Foltz from Laura. Supports the bill, does not wish to speak. Sharday Burton from the Michigan Department of Health and Human Services. Supports House Bills 4632 through 4635, does not wish to speak. Aaron Van Langenfeld from the Department of Attorney General supports House Bills 4630 through 4643, does not wish to speak. Gabrielle Diesner from ACLU Michigan supports 4630 through 4643, does not wish to speak. Jen Peacock from the Michigan Center for Youth Justice supports 4630 through 4633, does not wish to speak, and I'll pass this on to my Senate colleagues here. Tom Hickson from the Michigan Catholic Conference supports House Bills 4630 through 4643, does not wish to speak.
Thanks very much. Okay, so we've got a little, go ahead.
There are a couple more, sorry.
Okay.
The State Bar of Michigan supports 4630, 4631, 4634 through 4637, does not wish to speak. Trevor Van Dyke from the Michigan Supreme Court, SCAO, supports 4630, 4643, does not wish to speak.
And on the Senate side, we have essentially the same cards, so we'll just put them in the meeting minutes, if that's okay.
Absolutely. Madam Chair?
The Criminal Justice Committee will go at ease. Would members please remain seated?
I am going to make a motion to excuse Senator Santana from today's meeting. Without objection, the motion carries. Being no further business, the Senate Committee on Civil Rights, Judiciary, and Public Safety is now adjourned.
The House Criminal Justice Committee will return to order. We'll be voting on House Bills 4634 through 4643. We previously took testimony on 4634 through 4637 on June 22nd, and testimony on 4638 through 4643 on June 27th. Cards pertaining to these bills will be reflected in the minutes and have been read in. And Representative Andrews moves to adopt the H3 substitute for House Bill 4634. Madam Clerk, please take the vote.
Chair Hope,
Yes.
Representatives Andrews,
Yes.
Carter. Breen. Young. Arbit. Stevendorf. Cerniglue. Filler. Mueller. Zak. Harris. DeVault. Madam Chair, you have 13 yeas, 0 nays, and 0 passed. The substitute is adopted.
Thank you. I'll take a motion from Representative Breen to report 4634 with recommendation as House Substitute 3. Madam Clerk, would you please call the vote?
Chair Hope,
Yes.
Representatives Andrews. Carter. Breen. Young. Arbit. Stevendorf. Cerniglue. Filler. Mueller. Zak. Harris. McCall. Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4634 is reported with recommendation as substitute H3.
Thank you. And just moving right down the line here, I'll take a motion from Representative Young to adopt the H1 substitute for House Bill 4635. Madam Clerk, would you please take the vote?
Chair Hope.
Yes.
Representatives Andrews. Carter. Breen. Young. Arbit. Stevendorf. Cerniglue. Filler. Mueller. Zak. Harris. DeVault. Madam Chair, you have 8 yeas, 5 nays, 0 pass. The substitute H1 to House Bill 4635 is adopted.
Thank you. Representative Arbit moves to report HB 4635 with recommendation as House Substitute 1. Madam Clerk, would you please call the vote?
Chair Hope.
Yes.
Representatives Andrews. Carter. Breen. Young. Arbit. Stevendorf. Cerniglue. Filler. Mueller. Zak. Harris. DeVault. Madam Chair, you have 8 yeas, 3 nays, 2 pass. House Bill 4635 is reported with recommendation as substitute H1.
Thank you. Representative Carter moves to adopt the H1 substitute for House Bill 4636. Madam Clerk, would you please call the vote?
Chair Hope.
Yes.
Representatives Andrews. Carter. Breen. Young. Arbit. Stevendorf. Cerniglue. Filler.
Madam Chair, a quick question. Are we just adopting the sub right here on 4636?
This is to adopt the H1 substitute to House Bill 4636.
This is the sub, not the actual.
Sub. To adopt the sub.
Thank you. Yes.
Mueller. Zak. Harris. DeVault. Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. Representative Devendorf moves to report House Bill 4636 with recommendation as substitute H1. Madam Clerk, would you please call the vote?
Chair Hope.
Yes.
Representatives Andrews. Carter. Breen. Young. Arbit. Stevendorf. Cerniglue. Filler. Mueller. Zak. Harris. DeVault. Madam Chair, you have 8 yeas, 0 nays, and 5 pass. House Bill 4636 is reported with recommendation as substitute H1.
Thank you. Representative Cerniglue moves to adopt the H1 substitute for House Bill 4637. Madam Clerk, would you please call the vote?
Chair Hope.
Yes.
Representatives Andrews. Carter. Yes. Breen. Young. Arbit.
Yes.
Divendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Pass.
Bazar.
Pass.
Harris.
Yes.
Bagol.
Pass.
Madam Chair, you have 10 yeas, 0 nays, 3 pass. House Bill 4637, or the substitute, H1, to House Bill 4637 is adopted.
Thank you. Representative Andrews moves to report House Bill 4637 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Yes.
Divendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
No.
Bazat.
No.
Harris.
No.
Bagol.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. House Bill 4637 is reported with recommendation as substitute H1.
Thank you. Representative Carter moves to adopt the H1 substitute for House Bill 4638. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green. Young.
Yes.
Arbit.
Yes.
Divendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Bagol.
Pass.
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 12 yeas, 0 nays, 1 pass. The substitute is adopted.
Thank you. Representative Breen moves to report House Bill 4638 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green. Young.
Yes.
Arbit.
Yes.
Divendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4638 is reported with recommendation as substitute H1.
Thank you. Representative Young moves to report House Bill 4639 with recommendation. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit.
Yes.
Divendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Bagol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. House Bill 4639 is reported with recommendation.
Thank you. Excuse me. Representative Arbit moves to report 4640 with recommendation. Would you please call the vote?
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit.
Yes.
Divendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Bagol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. House Bill 4640 is reported with recommendation.
Thank you. Representative Divendorf moves to report House Bill 4641 with recommendation. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit.
Yes.
Divendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Bagol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. House Bill 4641 is reported with recommendation.
Thank you. Representative Cerniglu moves to report House Bill 4642 with recommendation. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green. Young.
Yes.
Arbit.
Yes.
Divendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Bagol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. House Bill 4642 is reported with recommendation.
Thank you. Representative Andrews moves to report House Bill 4643 with recommendation. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit.
Yes.
Stevendorf.
Yes.
Serniglim.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Pagol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. House Bill 4643 is reported with recommendation.
Thank you. Good work, committee. There being no further business before the committee, we will stand adjourned.